We'll take your seats. Committee will get started. Let me welcome everybody to the 2018 session, Committee on Social Services and Rehab. We're going to take electronic roll. We're voting electronically now, so members, you're going to have to do it just like we do on the floor. So, Marianne, if you'll hit the roll. Okay, I think we have a quorum. Okay, next I'd like to just give a few opening remarks and introduce some of the staff. Before us, directly in front of me, we have Marianne and Rachel is out in front with David May, our clerk attorney, Hobie Lehman, and Jonathan Palmore are here as well, my chief of staff. Cassie Horn is here, and then we have 2 pages. We have Langley. How do you pronounce your last name, Langley? Amory. Okay, I can read the writing now. And Shona, how do you pronounce your last name, Shona? Aceto. Okay. And Shona, you're from Ashburn, is that right? And Langley, you're from Poquoson. Okay. Well, my wife went to Poquoson High School, so I know how to say that word. Let me just. I don't know if we don't have any new members on P&E, so I don't know if we really want to go back and introduce ourselves, but I'd rather just get into the docket. We kind of have a heavy docket to get through today to get out to the floor on time. So with that, I'd like to go ahead and start hearing bills, but I have a few admin things I need to do. At the request of the patron, Senator Hanger, Senate Bill 233. He asked that bill to be stricken. Do I have a motion?
So moved.
Second. Okay, we have a motion and seconded to strike Senate Bill 233 at the request of the patron. All those in favor, please vote. Second bill we have is Senate Bill 239. We've heard in this committee before by Senator Marston. Let me read that. Yep. Last vote, ayes 14, nays 0. Next bill we have is Senate Bill 239, Senator Marston, which has come to this committee before. We're just going to re-refer that back to where it's been heard every other time to court. So I'll entertain a motion to re-refer to courts. All right, it's been moved and seconded to re-refer. Please vote. Okay, let's get started on bills. Yeas 14, nays 0. Senator Favola. At the request of the patron, Senate Bill 43, Senator Favola, to be stricken. Do I have a motion? And it's been seconded. Marianne, can you pull that up and let us vote? Ayes are 14, nays are 0. We just struck the wrong vote. All right. We're learning. Okay, it's 15-0. That bill is stricken. Anybody else want to strike their bills? We'll take a few more if you want. All right, first up in the queue, Senator Peake. You're at the top of my list. Please bring your attention to Senator Peake. It's going to be, what's your Senate bill?
342, Mr. Chair.
342 on the last page of the docket. Senator Peake, the floor is yours.
Thank you. Good morning, Mr. Chairman and members of the committee. I'm here on Senate Bill 342. Briefly, this was brought to my attention in meeting with various boards of supervisors, and in particular, the reason they're talking about the problem they have with holding prisoners after their 61 days, prisoners who have been convicted of felonies, who should be
Thank you. Does any member of the committee have a question? I know if this bill passes, it's going to have to go to finance for sure.
There we go. Oh, my goodness. Everybody missed all my good stuff.
No, I
think I'm
heard
just
you,
gonna
Mark.
leave it right there.
I heard you.
All right, good.
So, Mark, if you have a witness, you want to bring him forward?
I do, Miss Katie. Boy.
Good morning, Mr. Chair, members of the committee. I'm Katie Boyle. I'm with the Virginia Association of Counties, and we're here to support this bill. We would appreciate any relief that the state could provide. As the senator said, per diems for state responsible inmates are $12, and they've been set at that level since 2010. And so meanwhile, costs for everything have increased, and that payment has not. So we appreciate the senator bringing this forward, and we would appreciate your support. Thank you very much.
Yes, ma'am. State your name and who you represent.
Yes, sir. I'm Janet Arison with the Virginia Municipal League, and I would just like to mirror what Katie said. And actually, the $12 a day that was set in 2010 was actually a reduction. It used to be 14, and then it's been 12 ever since. And costs have gone up ever since, and the per diem has not. So thank you very much. We do support Senator Peake's bill.
Senator Black.
Well, they are getting the $12 a day, so they are paying a very low rate that has not been raised since 2010. And the other part is they're not picking up the prisoners. And so that's what happens is they're convicted of a felony, they're sentenced to more than a year in jail, and instead of picking them up after 61 days or 90 days, they just leave them there, and the local jails are carrying the tab. So the real problem is they are not picking up the prisoners. And of course, the reimbursement rate is $12. So they are paying the $12, Senator Black.
Senator Black.
Just to follow up, so, okay, after that 60-day period, doesn't that $12 stop?
No.
Am I incorrect?
Yeah, state continues to pay the $12. And the actual cost is $43. For Central Virginia, statewide, the actual cost is $46, and the state's paying $12.
So it's correct to say that every day that they are held by jail, they are being paid, but the problem is the amount that they're being paid does not cover the cost.
Yes, Senator Black, the amount they're being paid is $12. The cost statewide is $46.
Mr. Jones. Senator, hold on one second, Mr. Jones. Senator Sproul, you have a question? All right, go ahead. You're up, John.
Good morning, Mr. Chairman and members of the committee. The Sheriff's Association supports the bill that pays $12 plus the state pays the salaries that's approved by the comp board for the deputy sheriff that are approved by the comp board. So if you say the state only pays $12, that wouldn't be exactly accurate. You need to include too the salaries of those deputies. But we do support the bill. And I'm just sitting out in the audience, and I noticed a technical recommendation. If you move it forward on line 23, instead of locality, it ought to say sheriff. The sheriffs are actually the keepers of the local jail, not the locality by code. So if there's an agreement that needs to be reached, it ought to be reached between DOC and the sheriff, not the locality.
Okay.
Chairman, I think I would move that amendment.
All right, so we have an amendment to strike on line 23, locality, in place, sheriff. Is there a second to that motion? Okay, it's been seconded. David, are we good on that? Makes sense? Okay, so that is passed. So that amendment will pass. I guess we got to vote on it? Do we got to vote electronically? Oh, okay, it's just a voice vote, all right. Senator Sproul. Oh, I'm sorry. I'm a little rusty, guys. All those in favor say aye. Aye. Any opposed? Okay. Senator Sproul.
Yeah, before Mr. Sproul, Mr. Chairman, my understanding of what Mr. Jones said is that $46 figure is taking into account what the state is paying the correctional people.
Yeah, I just want to make sure.
But the state's paying the correctional employees, but it's still $46 after, yeah, including that payment. Excuse me, Senator
We
Sproul,
got
I'm
it.
sorry.
Go ahead, Senator Sproul.
Your microphone, sir. No.
My first question is, are you, in after time is up and they won't come and pick them up, are you saying because they won't pick them up, you want more money, more than $12 because 6 days or whatever it is up? During the regular time, they get $12. Now the 6 days are up, they won't pick them up. Are you trying to get more money after the 6 days?
Yes, Senator.
Go ahead.
Yeah, yes, Senator Sproul, because after the 60 days, and is it 60 or 91?
60, I think.
It's 60, I believe. We may have 91 in there. Whatever that time period is, the prisoner is under the State Department of Corrections control. So once they are sentenced to more than 1 year in jail, and they get that, they become the state's responsibility. What is happening is there are 3,500 prisoners statewide now that the State Department of Corrections have not picked up once their date is due. And so they are then reimbursing the localities $12 a day.
All right, Mr. Chairman, the
Senator
second question then, after that period is up, now I'm hearing you were saying after the 61 days, whatever is up. So, but I'm trying to figure out how much should they get paid after time is up? How much?
Statewide, it's $46. For Central Virginia Regional Jail, it's $43. But if you average it out to all the low jails in the Commonwealth, the average is $46.
All right, last question, Mr. Chairman.
Senator Sproul.
Then after the 61 days is up and you send from $12 to $43, then where would the extra money come from?
It either should, we think it should come out of the Department of Corrections budget, because it appears to us that that money is included in the Department of Corrections budget.
Senator Peake, right now, though, it's coming out of localities, correct?
Yes, it is. Localities are paying $53 million or absorbing $53 million of cost to maintain prisoners that are the responsibility of the Department of Corrections.
Thank you.
Everybody good?
Mr. Chairman.
Senator McDougal.
Senator Peake, the way this is written, the locality would determine the cost of the inmate, per inmate, with no oversight or agreement from the Commonwealth. Do you think that's a good idea? Because I'm sure some localities would have a very different interpretation of their costs than others.
Yeah, that is a good point, Senator McDougal. But we want to be fair to the Commonwealth, actually. So instead of having just a statewide figure, some jails may do it much more efficiently when they're charged, and that might lead the Department of Corrections to decide they want to leave some prisoners in some jails that are efficiently run and take good care of their resources versus other jails that are higher. But there should be some oversight as to how the ultimate bill is set, or some kind of limits as to the maximum amount that could be set, because we certainly don't want local jails, I agree, fudging their figures to get more money out of the state than they're entitled to.
Mr. Chairman, I have
Senator McDougal.
one other question. Did you put a $54 million budget amendment to cut some other projects throughout the Commonwealth?
Senator McDougal, we thought that question might come up, and we submit that is actually in the Department of Corrections budget. So it does not need a budget amendment, and it does not need to be sent to finance, because that money is in the Department of Corrections budget.
Mr. Chairman.
Senator McDougal.
So in the Department of Corrections budget, there is money that does go to local jails, but you're asking for $54 million additional dollars to go to localities.
Actually, Senator McDougal, we're asking the State Department of Corrections to come pick these prisoners up. So if they would come pick up these 3,500 prisoners, we wouldn't ask for a nickel.
If you don't have a $54 million budget amendment, my guess is this one's going to have a short shelf life.
Senator Peake, this is going to finance. I think Senator D-Staff's next in the queue. Senator D-Staff?
Is there a rep from DOC with us today? No one from Department of Corrections?
Someone's here
There
in
we
the
go.
corner. Yes, ma'am. Step on up.
Mr. Chairman, if I may, I've got a couple of questions.
Senator D-Staff.
How much does DOC get to care for these prisoners on a per-prisoner basis? Reimbursed from the federal government, I'm sorry. Let me clarify that.
Can you state your name?
Yeah,
and-
thank you. Marie Vargo, Department of Corrections. We don't receive the federal funding for prisoners in the state system.
Correct. That's what I thought. So if you had to pay the additional $54 million, where would it come from?
We would have to cut operating costs, existing operating costs, to carve that out.
Mr. Chairman, when it's time for a motion, I'm happy to make it.
Okay. Any other members of the committee wish to ask a question? All right. I'm sorry, my seatmate here. Senator Cosgrove.
Yeah, I would just remind the senator that today is the last day for a budget amendment.
Thank you, and I will take that note. I will say federal prisoners, we are reimbursed more for. So the federal prisoners are not the issue. It's the state prisoners that are not being picked up, and it is Friday. Thank you.
Senator Peake, you want to wrap it up? Is that your wrap up?
That's my wrap up.
Mr. Chairman, I move that we report and re-refer to finance.
Okay, I have a motion to report and re-refer to finance. Marianne, you ready to go?
Ayes 15, no 0.
Okay, you're out of here.
Thanks, sir.
Have
Thank
fun
you.
in finance. Okay, next up, we have Senator Howe, patiently waiting.
Good morning, Mr. Chairman and members of the committee. I have Senate Bill 267.
Okay, the committee will bring its attention to Senate Bill 267, Sexually Violent Predators Assessment Protocol. Go ahead.
A number of years ago, when we set up the civil commitment process for sexually violent predators, we actually had a problem. There was no really good assessment tool as to who should be civilly committed. So there was always the risk we would be putting the wrong people in and keeping the people that should be in out. In the dozen or so years since then, more assessment tools have come forward. And the one that we specified in the code that we would use, the static 99, is no longer considered sort of state-of-the-art or the best to use. So, and additionally, it had said that any other assessment tool used had to be approved only by the Commissioner of Behavioral Health. This bill opens up to both the Director of the Department of Corrections and Behavioral Health to come up with the best, most evidence-based assessment tool to use. And that's the purpose of this. It also extends from 10 to 24 months the time for the review of the prisoners, and that's at the request really of both departments who feel 10 months was not sufficient.
So, Senator Howe, they're having some time to develop this at this point? Is that the?
There are currently available better assessment tools, and so this would basically enable us to use them.
Is your commissioner here that's working this?
We have, where'd she go?
I only ask because I'd like to know what you're thinking on this.
Mike Schaefer, the Department of Behavioral Health. I'm the Assistant Commissioner of Forensic Services. We've worked closely with the Department of Corrections on this bill. Right now, as Senator Howell said, the code references the static 99. The static 99 is outdated, and they've come up with a new tool, the Static 99R. What we're suggesting is don't name a tool in the code, because every tool is eventually going to become antiquated. And if it's in the code, then we're sort of stuck using an antiquated tool. So we want the flexibility for us to work with the Department of Corrections to use the most state-of-the-art assessment method to determine which inmates should be screened for admission to our program.
Okay, thank you very much. Senator DeStaff.
If I may, one quick question, because the code currently says static 99 or similar score on a comparable, so it gives you the opportunity to look at another test. The problem I have here is we're deleting all of that and we're making it very subjective when we say who appear to meet the definition of sexually violent predator. So we're throwing out any and all scientific testing whatsoever. We're now turning it to subjective based on who appear to meet the definition.
I
think the code, the way it's written today, if I'm not mistaken, it says or similar, so it gives you an opportunity to use static 99, static 99R, or any comparable test out there.
Senator Howell, you want to take that?
Well, the way it's written now doesn't include the Department of Corrections, which is actually where they're located when they're being tested. I think what we are also trying to do is to get rid of the specific reference to what's known to be not one of the best assessment tools. And that's been in the code from the beginning because it was actually the only one available back then. This was brought up in Senator McDougal's subcommittee in finance last year. And I've been sort of following up on that.
Mr. Chairman, if I may.
Senator DeStaff.
Just so then on line 24 and 5, we've provided that new assessment protocol you're looking for. In line 28, if we didn't strike it, we still have the ability to do it. But in line 24 and 25, that addresses it. However, in line 33, you make it so subjective that it's, who appear to meet the definition. So I think this needs some more work still, Mr. Chairman.
Do you want to wordsmith it? And can I
Mr. Chairman,
punt down to Senator McDougal for a second?
If you look at the current code on lines 33, it does have that language, the offender appears to meet the definition. So that is, I think, a consistent timeframe with this. So I understand what Senator DeStaff means, and he might not like the appears language, but that's been the language we've been using for the last number of years.
Mr. Chairman.
Senator Favola.
Just a question for the patron and maybe the technical expert. Isn't it possible that the state of the art has progressed to such a degree that the assessment tools would be quite different from that static 99? So the concept of similar really is outdated. Is that a fair understanding?
Yes. Yes. When we started doing this over a dozen years ago, it was really cutting edge new stuff. And we wrestled in the Crime Commission for over 2 years in how to implement it. And there was a lot of resistance to doing it at all. We tried to be as evidence-based as we could, but we knew that the static 99 in the long run wasn't going to be the best assessment. And this is trying to update that.
A quick follow-up question, Mr. Chairman.
Senator Favola.
Is this really a recommendation from the Crime Commission?
This specifically, no, they didn't look at it at all. It
Okay.
came out of Finance Subcommittee and then working with
But
the
there
two
have been other
departments.
committees that have really looked at this and
Senator
studied
Favola,
it.
go through the chair, please.
In the past, putting together this whole civil commitment was a multi-year effort by the Crime Commission mostly.
Thank you, Mr. Chairman.
Mr. Chairman.
Senator McDougal.
I did have a question about the 24-month timeframe. How many of the individuals that are civilly committed have been sentenced to a criminal offense that would have them incarcerated for longer than 24 months?
My name is Eric Mattson with the Department of Corrections. I'm the Sex Offender Screening and Assessment Unit. So to answer your question specifically, I would say that the majority of the offenders that we screen are incarcerated for periods longer than 24 months. But there are some that are being sentenced for a couple of years and are in jail while they're going to court, so they have time served type of thing. The 24 months just allows for greater flexibility in us to be able to regulate the flow of offenders, as well as do better research to understand each case.
You good? Okay, any other members have a
Mr.
question?
Chairman?
Senator Hanger.
Thank you, Mr. Chairman. I would ask, do you believe that this would incur any additional costs in having this additional review?
And negative, in fact, I believe it would save some money.
Save some money, okay. Well, good.
Senator Black.
Mr. Chairman, thank you. I was very, very focused and interested in this particular legislation during the years that it was coming up. And it came about because there were some tremendously hideous cases out there with people who were such a clear and present danger upon the instant of their release from prison that they threatened the lives of people in the community immediately. And I think it was a tremendous advance when we put them in. And I guess I'm a little bit nervous when we talk about just sort of generally changing the standard without having a specific standard to look to. And I don't know whether we're confining people we should not be confining, but I know there certainly are some people who should be kept in an institution indefinitely. And so I'm just wondering if we take out any standard at all, and I understand that the one that we have is perhaps not looked at as being the most modern and up to date, what are we going to replace it with? Do we know that?
One of you guys want to take that? You've mentioned several things, but what you're looking at right now, I think, is what Senator Black is trying to understand what you're backfilling with.
Yes, sir. The static 99 is not only outdated, it is not recommended to be used by the scientific community. And in fact, the protocol looking at an actuarial measure in isolation is highly recommended against. So the protocols that we are proposing is to continue to use the static 99R, the newest version of that, to use base scores as Senator Steph was concerned with, but then to have the ability to further focus in on the aggravating characteristics and so forth, that to make sure that we're capturing the right offenders for this process.
And Mr. Chairman, one more
Senator Black.
question. When you do this assessment, are you bound absolutely to follow that, or do you have a board or something that has discretion to say, look, we understand what this assessment has come up with, but for the following reasons, we think that this person can be released? Do you have that authority?
Not exactly. Virginia is unique in the sense that this is the only legislation of civil commitment for sex offenders in the country that mandates a particular instrument to be used. Most other states use this kind of appears to meet definition in their code. We do have the ability to use aggravating circumstances or mitigating circumstances when it comes to medical conditions to bring cases in that do not meet the statutory threshold score-wise on the instrument.
You have that discretion?
Yes, sir.
Now.
The instrument, in scoring the instrument, it should be noted that it is not a purely objective instrument, sort of in the same way that you would look at an X-ray and know someone's bone is broken. This is much more, there are some subjective things as far as the scoring goes. So subjectivity is inherently a part of this process.
Thank you.
Senator Howe, I think we might have a friendly amendment to alleviate Senator DeSteff's concerns on your bill. Do we have that, David?
Yep, Mr. Chair, there'd be two amendments, the first of which is on line 24. After using, strike and insert a scientific. The other amendment would be on line 33. After who, strike appear to.
Okay. So Senator,
Mr. Chairman.
Senator Howell?
I'm sorry.
Go ahead, you're fine.
Well, I have a little trouble with the scientifically, was it valid or whatever the word, because I don't think they're done that way. We could do evidence-based or something like that, but what?
David, how does that, as far as letter of the law go? Okay, you good with that? So we'll change that to evidence-based instead of scientific-based on that line. Senator McDougal?
Mr. Chairman, on the peers piece of this, if I'm listening and just understanding how this process goes, the definition, it doesn't work like that. It's not like a strict definition. They take into consideration mitigating factors, but they also take into consideration aggravating factors. So if we struck that appears language, which is in the current statute, then none of those aggravating factors would be able to be considered in the future. So you could have an individual who had a significant number of aggravating factors, but based on the form, you would not be able to civilly commit. So I have some concern about eliminating that appears that we currently use today, because I think that that's going to miss some of the population that we're trying to capture with this statute.
Okay. Senator Wexton?
Mr. Chairman, I actually have a question that's not on this particular topic. So
Oh, okay. I'm sorry.
if you want to finish with the amendment.
Senator Steph?
I like the evidence-based.
Sorry, Mr. Chairman. I'm not an attorney, so if who appears would mess up the way the law is handled today, then I guess we put that back in. But that seems very subjective to me. And if it would just make it the hard definition of, and the law needs to be more subjective there, then so be it. We'll leave it to appears, and then just put evidence-based in line 24.
Okay, so the only change we're looking at is the evidence-based, Senator Howell, at the front. Are you good with that?
Yeah.
Okay, so, okay, we've got a motion and a second. All those in favor say aye. Aye. Any opposed? Okay, so the bill stands before us.
Move to.
No, Mr. Chairman, I have a question.
Senator Wexton.
Thank you. On lines, the original bill on lines 34 and 35, it says that the director may exclude from referral prisoners who are so incapacitated by a permanent and debilitating medical condition or terminal illness as to represent no threat to public safety, and that language has been stricken from this bill. Is that because these assessment tools take that into account, or can you explain why that language is being stricken?
It would already be accounted for in the protocol process that we're recommending.
You good?
Move to report as amended.
Okay, it's been moved and seconded to report the bill. Clerk, call the roll.
Ayes 13, nays 2.
Okay, ayes 13, nays 2. Your bill's out of here. Thank you, Senator Howell. Next, we have Senator Edwards. You're up.
Mr. Chairman, members of the committee, first talked to Senator DeSteph last night on a bill that I may end up striking it, but I have a call in to this is Senate Bill 296.
Committee will bring its attention to Senate Bill 296.
Yeah, yes, that's right. The bill, what it would do is to give the sheriff's right to go to court to have an incapacitated person, somebody who cannot give informed consent to have mental health treatment. The DOC has that authority. The sheriffs don't necessarily have the authority. I'm getting conflicting information as to whether or not they actually have the authority. I'm told in many places they're doing it anyway. I got a call from a forensic psychiatrist who does a lot of this work from Roanoke. He said, you need legislation. I've also got a call into the attorney who's involved in a particular case, and I'm coming to the conclusion that we probably don't need the legislation. And I talked to DeSteph last night, so if I could have a week, I'm probably going to strike the bill. But I haven't gotten a call back from the attorney.
Senator Edwards, I'd love to give you a week, but I can't give you a week. So you want to strike your bill?
No.
Okay, so the bill's going to be heard, so present.
Well, I've told you what I think the bill does, but I think I'm not in a position to kind of advocate for the bill either. So there, I really think I need a week to, and I'll find out maybe today. I think I have a call in to the attorney. He hasn't called me back.
Senator Edwards, I'd love to be able to punch your football down the field, but I can't do that today. So the committee will take a motion to either pass the bill or have the bill go by.
Mr. Chairman,
Senator Favola?
point of inquiry. In the past, if a patron came forward and made a similar argument to the argument being made before us by Senator Edwards, we did allow at least just a carryover for one meeting. I don't see what harm that would do if we could have more information on the bill, or if the patron may be able to come to a better conclusion about how to either approach the bill or to strike it. I don't see what harm that will do. We are going to meet next Friday. I guess I would make a plea on behalf of Senator Edwards as well.
Mr. Chairman, I did speak with Senator Steph yesterday. We
Senator
talked about
McDougal.
something like
Mr. Chairman, I thought we tried to make it abundantly clear yesterday on the floor that with the number of bills that we have this year, the number of very important time-consuming efforts to go through the budget, that we're going to be moving dockets as quickly as possible. And that means that a number of bills are not going to get second chances. If they're not ready to go forward, then they're not going to be able to go forward. I think what Senator Edwards is saying is that he doesn't think his bill is going to go forward, but certainly there are other remedies for him if we move to PBI this bill today and he finds out something differently next week. So, Mr. Chairman, I understand what Senator Favola is saying, but I think everybody is operating under the same process as we go forward. And so with that, Mr. Chairman, I would move to gently PBI.
So I have a motion to PBI. Do I have a second? I have a second.
I'd like to speak to that before we do it.
Senator Cosgrove.
Hey, Senator Edwards, I had a very important bill of my own yesterday, and basically I had no chance to bring it forward or have any other witnesses or whatever. It was important to my area, but I mean, that's not just for you, it's for everybody. So I suffered it yesterday, so anyway.
Okay, the bill's before the committee. It's been properly motioned and seconded. Clerk, call the roll.
Ayes 12, nays 3.
Ayes 12, nays 3. The bill to PBI is done.
Okay, you're going to love this one. It has to do with guardianships, and given to me by the Supreme Court of Virginia.
Senator Edwards, what's the bill number?
Yeah, I'm sorry. It is Senate Bill 156.
Committee will bring its attention to Senate Bill 156, please.
And just this morning, we have been in the hallway trying to work out some issues. The nursing homes and some others have some issues with the wording. And everybody thinks if we had a week, we could work it out. And the Supreme Court of Virginia is here and asking that the bill go by for a week so we can work out. We can't do this on the fly. And so, Mr. Chairman, being an attorney who also has a petition for appeal in the Supreme Court of Virginia, I'm not about to go against the wishes of the Supreme Court of Virginia. And so the representative of the Supreme Court is here. Here she is. And she can make the request too.
Senator Edwards, is there a House companion bill to this?
Yes, there is.
Okay, so you'll have an opportunity for this bill to be heard in the House as well?
Yes.
Okay, so you'll have that opportunity. So are we ready to go forward today?
I'll let Supreme Court explain.
Okay.
Good morning, Mr. Chairman, members of the committee. My name is Alyssa Padden. I'm with the Office of the Executive Secretary of the Supreme Court. This legislative proposal is the work of a group that goes by WINGS. It's Working Interdisciplinary Networks of Guardianship Stakeholders. This is a group that was convened by Chief Justice Lemons in 2016, and they are engaged in reviewing the process of guardians for incapacitated persons, and they make recommendations for how to improve that process. So the goal of this legislation is to ensure that there is another review of the report that's filed by the guardian of an incapacitated person annually. So what this legislation does is it would require the local Department of Social Services to review the report of the guardian before filing it with the court. And it would also require that the guardian include a report of a professional skilled in the treatment of physical or mental conditions to certify that the treatment and care of this person is appropriate. We do have a line amendment that we had worked out within the last day or so that would allow the court to waive the report requirement for good cause shown. And we think that that would address any concerns that the guardians may have with whether this reporting requirement would be appropriate for every case. We do have a member of the WINGS subgroup here who can answer any additional questions.
Do you want to, Senator Edwards, do you want to go forward with the line amendment?
We got two of them, actually. One is line amendments that's been written by Legislative Services. It says on page 1, line 36, after 8, strike A, insert unless waived by the court for good cause shown, comma, A. And the second one has to do with changing an and to an or on line 39. It says concerning the physical and mental condition, change the word and to or. So it says the physical or mental condition on line 39. So I would ask that the committee consider those two amendments.
Move those in a block.
Okay, it's been moved and seconded to do those amendments. All those in favor say aye.
Aye.
Any opposed? David, did you get those?
Mr. Chair, if they could just repeat the first amendment, I have the second.
Okay, the first one is, here it is. I can give it to you. It's under page 1, line 36, after 8. And it says before the words "a report," it would say unless waived by the court for good cause shown, comma, a report. You want to copy this?
Any members of the committee have a question for Senator Edwards?
Mr. Chairman.
Senator Black?
Yes. A question for the representative of the court.
Yes.
With those amendments, is the court satisfied that the legislation says what the court would be content with?
Yes. The WINGS subgroup has reviewed that line amendment and is comfortable with making that change.
I see. Okay, thank you.
Okay. Any other members have a question? Senator Mason.
Who would determine good cause shown to not require a report? How walk me through the process of how that would work?
The court would make that
The court would
determination.
and they don't need, Mr. Chairman? So they don't need the report, they don't want the report?
Well, the guardian would have an opportunity to make their argument to the court that that report should not be required in any given case.
Mr. Chairman?
Senator McDougal.
Picking up on what Senator Mason just asked, so right now, if somebody's appointed a guardian, each of those cases are going to have to go back on the docket for if the guardian doesn't want to have to file a report.
Well, I imagine.
Or have that specific analysis done.
I think that language is broad enough that that concern could be addressed in different stages of the proceedings. So, for example, it could be addressed in the guardian's appointment order, or if the guardian is brought before the court on a show cause for failure to file an appropriate report, they could make their argument about the waiver at that time.
Mr. Chairman.
Senator McDougal.
So I agree with the appointment order for all cases going forward, but for all guardians that have been appointed historically, now there's a new requirement that they have to do. And if their particular situation doesn't meet the requirements for needing that, they're going to have to file a motion, go back in front of the judge, because nobody wants to be show caused.
Yes, I think that's correct.
So you're going to create a lot of additional court time for people going back.
I think that's correct for cases where there's a reason why the report requirement wouldn't be appropriate.
So, Senator McDougal, is there a fix to that, or do you want to stand by?
These are done informally. Yeah, you can call the judge, hey, judge. They're not done in a formal docket. I mean, they just show up, go up in the judge's chambers and say, hey, that's what happened.
Okay. At the advice of my counsel on the end of the table, who seems to be in courts all the time, and this is going to cause a problem, Senator Edwards, the recommendation is that we re-refer this bill to courts of justice, where there's competent attorneys there that truly understand it. We only got a few here. So I would
that motion, Mr. Chairman.
have a motion to re-refer your bill to courts of justice. All those in favor say aye.
Aye.
Any opposed? It's a recorded vote. It's a recorded vote. Okay, Senator Edwards, is that all you have today?
That's unfortunately all I have.
Okay, thank you. Okay, next.
Yeah.
Next up, Senator Stanley. I see you waiting in the wings.
Good morning, Mr. Chairman. Which bill would you like to kill first?
Well, you can kill all you want on your own if you'd like.
Put in a block.
Go ahead, Senator Stanley. What do you got for us?
Mr. Chairman, I've got three bills, so let's start with the lowest number. We'll just do this in numeric order since I'm a very simple man from the country. Senate Bill 36 is weekend jail time. It's been before this committee a couple of times. It's gotten out of the Senate before, and then, of course, the House has just basically shut it down. I mean, Delegate Klein has basically killed this bill. But what it does is, this is a recommendation from the Virginia Criminal Justice Commission. Basically would change the code to permit those persons convicted only of non-violent felonies, if their sentence of active time is 90 days or less, or gets to the point of 90 days or less, that they can be, with the consent of the Commonwealth, only by the consent of the Commonwealth's attorney, and of course the acquiescence of the judge, be sentenced to do their time on weekends. There is a reason for this, and here is why. You know, in my other life as a criminal defense attorney, what I see oftentimes is that there's a lot of these nonviolent felonies or drug offenses. The person is maybe addicted or in possession. Usually it's an offense such as that, and half the time they're working addicted. And so if they are sentenced to active time under the sentencing guidelines or by a judge, even a sentence of 60 days of active time can be a death sentence for their job. And so what this tries to do is allow that person who may have made a mistake and is serving time and is paying their penance to the community and to society, the ability not to lose their job. Because here's the other reason. When they come out, and I'll use clients in Moss as my example, when they come out and they've lost their job and now they're a felon, that employer would have kept them on had they had the ability to be there Monday through Friday. But because they couldn't be there Monday through Friday for the next 60 days, they had to fire them and find somebody else to fill that role. And when they come out, their job is now filled by someone else, and many times employers are unwilling to give that person who made that mistake and who suffered the felony and who paid their debt to society a second chance. What we're trying to do with this bill is to create not tax burdens, but taxpayers. We are a land of second chances. And if we believe in those second chances, then we have people that are in these positions with non-violent offenses, no offense against humanity, no violent offense against a person, but a conviction that is non-violent in nature, then quite frankly, if the sentence is below 90 days, we shouldn't be we're branding them with a scarlet letter. Let's not do it to the point where we're basically taking away their ability to thrive when they get out and not commit another crime.
Mr. Chairman.
Senator Wagner.
Did we not pass this bill out of here 15-0 last year?
Not last year, I think it was the year before. Or maybe it was last year, yes. Yes, it was.
Mr. Chairman, identical bill. I moved to report, but.
Let me get Senator Cosgrove first. Senator Cosgrove.
Thank you. Also, in the language of the bill, it says that this won't happen if the Commonwealth objects.
Mr. Chairman, I'd answer the gentleman by saying it's only with the consent of the Commonwealth.
Right, exactly. And I have one other question, Mr. Chairman.
Senator Cosgrove, finish up, and then we'll get everyone.
Yeah, that's fine. Basically, weekend time, as I understand it, if they go in Friday by a certain time, they're Saturday and they're let out, a little after noon on Sunday, they actually get 3 days credit. Is that correct?
Mr. Chairman, I'd answer the gentleman that that is correct.
Okay. Thank you.
But, Mr. Chairman, I'd also say that in felony situations, when we calculate time, it's not what we do in misdemeanors, which is 50-50.
Right.
So if you get a 60-day sentence, you actually pull 30 days, it's 85% of the time they'd be serving of that sentence.
Gotcha. I've got Senator Mason in the queue, then Serval. And for members, you have on your screen, you can request it'll pop up here. I'm trying to see you and hear you at the same time.
Thank you. Thank you.
Senator Serval.
Mr. Chairman, question for the patron.
Go ahead.
In light of the fact that we've passed this probably 5 times and we have a really long docket today and a really long docket beyond this, I just had one really quick question. I remember when I lived in the other body, having this bill come through a subcommittee I was on, my recollection is that at that time it did not have a requirement of the consent of the Commonwealth in it, and that this body had passed it without that provision in it before. I was just curious as to whether or not the gentleman, and that the Criminal Justice Conference actually passed it before without giving the Commonwealth the keys to the weekend jailhouse. I was just curious whether the gentleman viewed that as a friendly amendment to see whether or not the House still felt so strongly about that, or whether you would prefer to leave it as is and send it over there the way it is right now.
Mr. Chairman, I'd answer the gentleman, my friend from Fairfax, by saying years ago it was not a friendly amendment. At this point in time, what we've seen, and I've seen since then, and there are a lot of times, and the Commonwealth knows these people too, and I trust them. You know, in smaller communities where I practice mostly, not maybe in Fairfax where, you know, it's a new Commonwealth attorney every day and they're churned through those offices, or even Arlington. But what I see is that most people understand and know these people. So, you know, where I've seen and talked with my Commonwealth attorneys, a lot of them are heartbroken that they can't do this. And what we've seen in the time and the years that I've brought this to the House is that we've seen many, many people suffer this and then lose their job and be in a position where they're a tax burden, not a tax benefit.
God, I second the motion of.
Okay,
Well,
I have another senator. So Senator Sproul.
Is there an amendment before us, Mr. Chairman?
No.
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 Okay. All right.
Senator Sproul.
Thank you. You keep using the word Commonwealth. Are you trying to say, for example, I represent 2 cities? So you're saying that, for example, Norfolk could say we'll do it, and Chesapeake said we don't want to do it. Is that what you're saying here?
Mr. Chairman, I'd answer the gentleman by saying that what would happen in each individual case when they're brought before the bar of justice, there's a prosecutor and a defense attorney in whatever county it may be, and based on that case-by-case basis, if the parties can agree and the Commonwealth does not object, that the person suffering from the felony and having 90 days or less to serve can serve that on weekends, then that's when it would occur. But it still empowers the Commonwealth's attorney at this time, when a defense lawyer like myself might ask that they serve non-consecutive days to keep their job, the Commonwealth could object. And with the Commonwealth's objection, then that would not be a possibility. And that can be, and so there's no uniformity except the ability, the tool is in the toolbox for the parties to have this. But ultimately, it will depend on the consent of the prosecutor in the case at bar.
Thank you.
Yes, sir. Thank you.
Mr. Chairman, I move
Senator
to
Black.
report.
Okay, so we have a motion to report. It's been seconded. Anyone else wants to speak to the bill real quick? You got Mr. Jones behind you, Senator Stanley. I think he'd like to. You good, John? Need to speak?
Mr. Chairman, the sheriff, excuse me. We're opposed to this bill because if you think about 90 days, that's 45 weekends. That's a lot of inmates coming into our jail on weekends, and that's when we have our busiest time. So we're going to create a real population problem coming in on Friday and leaving on Sunday for the felons that are under this bill. That's the time we get, you know, when we have people coming and going out of the jail, we're dealing with contraband, and the sheriffs are telling me they don't like the bill because of management problems and contraband coming in. So if you want to do this bill, it's going to create a management problem for the sheriffs. We're opposed to it.
Thank you, Mr. Jones. I do have, I think your bill's in good shape, Senator. If anybody else really needs to speak, I really need to get going on the docket. I have a motion before us to pass the bill. It's been seconded. Clerk, let's call the roll.
To vote for my motion. I guess I'll do it.
Ayes 14, nays 1.
Okay, the bill passes, aye 14, nays 1. Senator Stanley, your next bill.
Thank you, Mr. Chairman. Mr. Chairman, the next bill in order of number would be Senate Bill 174.
Committee will bring its attention to 174.
And Mr. Chairman, I may call you Your Honor because I've been used to doing that for a year, haven't been back, but I apologize. There is a floor, an amendment, committee amendment.
David, can you read the amendment?
Which number?
Mr. Chair, the amendment is after line 26. We're inserting a second enactment clause that reads that the provisions of this act shall not render valid the provision of any contract, written or oral, that was entered into prior to July 1st, 2018, and that was void under the law in effect prior to July 1st, 2018.
Okay, thank you. Go ahead, Senator.
So moved.
Okay.
Oh, I'm sorry. We do need to take it up. All right, so it's been moved and seconded. All those in favor of the friendly amendment, say aye.
Aye.
Any opposed? Okay. Bill before us.
Mr. Chairman, members of this committee, it's a simple bill which actually retracts some language in the existing code of 4.1-404 under sales territories of our wholesalers. Basically, what this does is give wineries the contractual option to enhance distributor accountability and prohibit destructive poaching that occurs in the distributor by wholesalers and distributors. It's a freedom of contract measure. It promotes bald eagles and apple pie. It allows wineries to enforce contracts which prohibit rogue distributors from poaching key accounts and sales territories that the winery has assigned to other distributors. Mr. Chairman, this basically brings this code in line exactly with the beer distributorship code section. And so now there's equanimity in contract and protections that are there. And so for those reasons, I would ask that the bill pass. Ultimately, the amendment, I would say, is something of a workout between the beer and wine wholesalers and also the Virginia wineries. And so for those reasons, sir, that is the bill. I ask favorable consideration.
Any members have a question for Senator Stanley while he's still up there?
Move report.
I second that motion.
Okay, there's some people to speak against the bill, I'm sure, so come on up.
Good morning, Mr. Chairman. I'm Terry Byrne, Eastern Council with Wine Institute. Wine Institute represents the California wineries, and we make a lot of wine in California, about 85% of domestic production. And we estimate that 14,000 Virginians have full-time jobs selling California wine, making $525 million in wages. We're opposed to this bill strongly because this issue, this code section 4.1404 is currently in litigation at ABC. Against 5 of my California winery members, Virginia wholesaler has brought suit. And there's an opinion, a recommendation for an opinion from the hearing examiners at ABC. And the wholesaler has announced that he's going to appeal it to the full board. So this issue is currently in litigation. And if you act on it this morning, you might be going against your longstanding policy of not taking up matters that are in litigation. And if you'll indulge me, I'd like to explain the practical impacts of this bill on wineries. The wine franchise law has a basic tenet that a wholesaler has to assign, a winery has to assign an exclusive sales territory to their wholesalers. Usually it's along city or county lines, and that territory is registered with the ABC. The parties may or may not have a written agreement to this effect. And under current law, the wholesalers can create new sales territory for themselves by merely selling into new counties and cities, by their course of conduct, if you will. This area beyond the assigned sales territory that's created by the wholesalers is what's deemed the primary area of responsibility in the statute. Think of the primary area of responsibility as a penumbra around an assigned sales territory, unless it's a statewide assignment, of course. Years ago, the wholesalers asked for this ability to bleed into unassigned territories and to poach into otherwise assigned territories. It created a situation today where wholesalers are commonly selling into territory that's not been assigned to them by wineries. And the ABC filings that we have made and the agreements between the parties often don't reflect the actual sales territory into which the wholesaler is selling. If the primary area of responsibility language is stricken, the law defaults back to the statutory assigned sales territory, which is in the definition section of the franchise law. The problem is that wholesalers have been poaching and bleeding for years, and the wineries have encouraged that. It's been a great relationship. But potentially now you have two wholesalers that are selling into the same sales territory, merely by their course of conduct, not pursuant to a written agreement. If this law changes, which wholesaler gets rights to those brands in the sales territory where their two wholesalers are competing? Both claim the territory, and the wineries are going to be forced to choose with their filing at ABC who gets it. So the chosen wholesaler gets an exclusive sales territory, and they eliminate their competition. Lucky for them. But the one that's not chosen is going to sue the winery for unlawful termination under the wine franchise law. So the winery gets a lawsuit, and they lose the wholesalers competing for their business. In summary, we're opposed to this legislation because it's already in litigation at ABC, and because it will carve Virginia up into a maze of exclusive territories that would kill competition, and it would require lawsuits against wineries to sort out this problem. And finally, it'll eliminate the little flexibility that wineries currently have under the Virginia wine franchise law. Thank you, sir. I'd be happy to answer any questions.
Thank you. New member, have a question? Okay, you're up, sir.
Mr. Chairman, members of the committee, Trey Adams on behalf of Winebow. We operate as a wine wholesaler here in Virginia as the country vintner. We're opposed to this legislation. In the interest of time, I'll adopt most everything that Ms. Byrne mentioned to y'all. The reality is the language that's in the code now creates an opportunity for competition. Competition brings better service and better price. If you adopt the bill, you eliminate the small window of competition that exists in the distribution of wines and limit the choice of customers and increase the price. For that reason, we hope you'll reject the bill. Thank you very much.
Thank you, Mr. Adams. Mr. Boykin?
Phil Boykin with the Virginia Beer Wholesalers Association. We wholeheartedly support this. We support wine wholesalers having the same rights that you've extended to beer distributors. So.
Thank you. Anyone else in the audience wants to speak to the bill? Okay, the bill in its amended form is before the committee.
Move to report.
Motion to move, it's been seconded. Clerk call the roll.
Ayes 15, no 0.
Ayes 15, no nays. That bill passes. Senator Stanley, I think you have one more about parental or legal custody powers.
Yes, Mr. Chairman, Senate Bill 178 concerns a pilot program that is now would be made permanent. Basically, what that does is it creates an opportunity for families to avoid social services when there may be a crisis or impending crisis. First, though, there are some line amendments and corrections.
Okay. David, do you have those?
Mr. Chair, the line amendments are a little bit lengthy, so I've gone ahead and made a copy for everyone. I'm going to get the page to distribute it now.
Mr. Chairman.
Okay. Senator Favola.
This was the amendment I said I would like to offer. It's viewed as a friendly amendment.
Oh.
Would you?
Okay.
We worked it out
Let's
yesterday.
get it passed out first, Senator Favola, and then we'll go through it. Dave will go through it. Just a real quick public service announcement for those in the audience today and my colleagues on the dais. You're being live streamed today, so the world now knows you're in rehab on Friday mornings.
That's funny.
All right, I think everybody has it. David, do you want to go over it real quick?
Sure, Mr. Chair. The second and third amendments are fairly technical. It just removes provision that was stipulating as to whether these nonprofit organizations participating in this program under the bill received public funds. They don't currently, but I understand they may get some sort of grant in the future. So it was more of a technical wording amendment there. And then the First Amendment was something that all the stakeholders kind of worked together to come to a compromise that puts some sort of level of regulation on these nonprofit organizations participating in the program that would require them to submit to background checks by the Department of Social Services, develop certain policies related to monitoring abuse and neglect of children, managing records, using seclusion and restraint, things like that. And then also providing training, ongoing training for providers and staff.
Senator Stanley, you're good with this friendly amendment?
Mr. Chairman, I am indeed. And I appreciate Senator Favola's efforts in making sure that we could come to a resolution that I think strengthens the bill.
Thank you.
Senator McDougal.
Mr. Chairman, as we're sitting down here, we were discussing this. If this were to pass, can an attorney advertise that they do child placement work and try to establish a practice or set up a system where they're routinely taking these types of powers of attorneys in? Because I would have some concern about that occurring, and my initial reading of this indicates that it could happen.
Mr. Chairman, I'd answer the gentleman, that's not the purpose, and certainly solicitation. We are bound by our ethics in certain cases not to be solicitous of those kind of clients. But in this, all this is doing is empowering parents when there's a crisis going on to avoid turning your children over to social services through a filter of a not-for-profit organization that vets any person that may be hosting these children during that crisis for a year or less, to allow them to, by power of attorney, delegate certain authorities, but not all authorities of parenting, and to make decisions of certain health, education, welfare for the benefit of that child during the period in which this crisis exists. Whether an attorney chooses to take advantage of something like that, I would hope not. It would be a blight on my profession.
Mr. Chairman.
Senator McDougal.
It's good.
It's a lot of things I want to say, but we are live streaming, so none of them are quite appropriate. Mr. Chairman, I would say that under the current rules, there would be no prohibitions against an attorney advertising that they engaged in this type of work, that they would accept power of attorneys to be able to do that. I realize that's not the intent of what you're trying to do, but there would be no prohibition to that if this bill would pass in its current form.
Mr. Chairman, I answer the gentleman in his soliloquy by saying, look, this is, obviously the filter is the not-for-profit organization like Safe Families for Children, and those organizations would vet the person who would be receiving the child. You know, everything we do here is the potential for abuse exists, but not in every closet does a monster lurk behind the shoes. So in this case, what we're trying to do is present those families with the opportunity not to have to put your child into the system, which then you subject yourself, as you know, Senator McDougal, to process. And it's a lot harder to get out. With social services, you've got those kind of overseers. This is a temporary act. And what we've seen here, Senator McDougal, is that in the pilot program, this has been highly successful. Nationwide, they've had 40,000 hostings, reunifications. They're serving these children in an abuse-free and neglect-free environment during that time. The people are vetted, so they're highly qualified people to receive these children and are aware of what's going on and how to handle maybe the internal strife and problems that may exist. And so what we're trying to do is to allow people to be diverted from foster care and with a rate of 100% reunification with that family, because not all problems are long-lasting. And this certainly is a temporary fix that empowers the parents to go and do something that will save their children and save them from harm.
Senator Serval.
Multiple questions to the patron, Mr. Chairman.
Go ahead on, but we're running short on time.
Yeah, I get it. This is a pretty big bill, actually legally. So would the patron agree with me that under the current law of Virginia and the common law traditions of this state, that if a parent wants to do anything involving their legal authority to exercise custodial rights of a parent, that it typically or always requires the approval of a court of law in this state? Would you agree with that?
Mr. Chairman, I would under most circumstances, yes.
Would you also agree that the reason for that, we always require court involvement, is that because a child typically doesn't speak at a custody hearing, doesn't have a right to have input, and so we always ask for a court to come and exercise an independent oversight to make sure the parent is actually making a decision that's in the best interest of the children before it's approved?
Mr. Chairman, I would answer the gentleman again in the affirmative, but I think, and those are In the 24 years that I've practiced law, I know that we've run up and down the courtrooms and courthouses together, that those are usually the most serious cases where that kind of intervention is required. We're not talking about probably those where court intervention is required. This does not eliminate those kind of cases from court consideration, intervention, and oversight. What happens is, in this situation, is where an impending crisis may occur or something that's going to happen that presents a problem to that family, that we're able to effortlessly, before the explosion, take care of that child in a
Would the gentleman agree, though, that with respect to these specific situations, you have parents that are either in crisis, whether it's emotional, physical, some kind of a drug abuse, serious mental illness, whatever, and we're basically authorizing them? It doesn't even, to me, seem to require the consent of the other parent, but it authorizes them 100% to just decide what to do with their kid without anybody else approving it.
Mr. Chairman, I answer the gentleman that if he has a lack of confidence in the parenting skills or the parenting rights of that particular parent in that situation, then intervention by the court system may be. But I believe that a parent has a right to make determinations for their children, that the government isn't always the best determinant and the best vessel to make decisions for our children. I don't believe, I think the government should be making decisions for my children, as I believe my friend, Senator Sturville, doesn't believe that the government should be making decisions for his children. What we're trying to do is really offer an alternative. It's not an elimination of the existing system. It's an alternative. But it also still respects the family unit, because ultimately, you've seen and I've seen where this stuff gets out of hand. It causes a lot of emotional scars and a lot of long-lasting effects through the court system. In special circumstances, not all, this could help in not only working through the crisis, saving those children from harm, and ultimately reunification.
Okay, Mr. Chairman, speaking
which is, again, the goal of our government.
Speaking of the bill at the appropriate time.
Okay, thank you. Senator Spruill wanted to ask a question, but okay, go ahead, Senator Spruill, real quick. And then Senator Chafin has a motion.
Thank you. Senator Stanley, the first question that Senator Maduga asked a question that is this a ambulance chaser bill like you see on TV, you advertise through chase accidents?
Mr. Chairman, I answer my good friend Senator Spruill by saying no.
Okay.
This is not.
The second question, I got my law degree from Law and Order on TV, so I'm trying to do like something. Actually, do you agree with me that because this is a lawyer's bill, I'm listening to all lawyers talking, that maybe we should go to court and let y'all lawyers work it out, so us folks who just watch TV law can understand what you're talking about?
Well, Senator Spruill, Senator Chafin seems to agree with you. Senator Chafin, do you have a motion?
Yes, Mr. Chairman, I do. While I think that the intention of the patron is laudable, I think this matter could best be handled in courts, and I'm going to move to re-refer it to courts.
In the amended form, correct?
Is the Senator Sturville in courts? No? Oh, okay, yeah, then I don't mind.
Senator Crossroads.
Just a question I'd ask the committee, have you been injured by this bill? Have you been hurt? Can Senator Stanley, really take you to court on this bill? I'm just curious.
Okay, so the motion before us, it hadn't been seconded. Is it seconded? Okay, it's been seconded, is to re-refer the bill in the amended form to courts. All those in favor say aye. Aye. Any opposed? Oh, it is a recorded vote. No.
Happy to join Senator Edwards' bills over there as well, I guess. Thank you, Mr. Chairman. Thank you for your time.
Ayes 15, nay 0.
Is that all you had, Stanley?
Mercifully, yes, sir.
Okay.
Thank you.
Senator McDougal, you want to take up your bill first? Senator McDougal, that's Senate Bill 306, correct?
Yes.
Okay, committee will bring its attention to Senate Bill 306.
Thank you, Mr. Chairman, members of the committee. Senate Bill 306, this was an effort between some entities that oftentimes have differing views to come together and establish what a brewery license would permit in Virginia. So, Mr. Chairman, I would say that the parties being the beer wholesalers and the craft brewers had a substantial amount of conversation during the off session, and the package before you is the compromise of that conversation. And the bottom line, Mr. Chairman, is in creating this brewery license, the biggest issue that I think that was resolved is there's a 20% threshold for the amount of beer that has to be brewed in the facility to be able to obtain a license. I know that there's a lot of conversation of is 20% too low? Some people might even think any percentage is too high. This number was a compromise number because people had differing views. But right now, with no regulation at all, somebody could set up a brewery and have a glass jar, mason jar, and call themselves a brewery and have tastings of any other beer that they would bring in, even though it's not brewed. So this does set some minimum, and the way we came to that 20% through the negotiation is that's traditionally the amount of beverage that would have to be brewed for you to have a brewmaster. So in the traditional sense, a full-time brewmaster would create it as a brewery. Mr. Chairman, as we went through this process, because there was so much negotiation, we had to get a version into Legislative Services before the deadlines and file the bill, and there were a couple amendments as everybody reviewed it to make sure that we were all on the same page. And I'd ask that staff report those, and I'm going to move them in a block.
Okay. David?
Mr. Chair, there are 4 line amendments, the first of which is on line 24. After that, strike the remainder of line 24 and all of line 25. The next is on line 26. After of the, insert volume of. The third line amendment is also on line 26. After consumption, insert in any calendar year. And the fourth line amendment is on line 138. Right after line 38, insert a second enactment clause that reads that the provisions of this act shall become effective on January 1st, 2019.
Mr. Chairman, again, I moved those amendments, and all those were to make sure that we had specific timeframes so that we weren't determining those timeframes differently. And we picked January 1st of 2019 to make sure that everybody could be fully apprised before the regulation went into effect.
Second motion.
So the amendments before us, all those in favor say aye.
Aye.
Any opposed? Okay, Senator DeStaff.
Can we report or just review the amendments one more time? So we're taking out the 3-barrel minimum? Am I understanding that properly?
Yes, Mr. Chairman, we are taking out the 3-barrel minimum, but having 20% of the volume.
Because previously it was 3, and I'm just trying to get the 3 amendments, or 4 amendments, I'm sorry.
Can I move forward while you're looking?
Please.
Mr. Lisk, you have people behind you, Senator McDougal.
Yes, Mr. Chair, and as I prefaced, I think not everybody, I think there's a lot of consensus that putting into place a specific structure is a good idea. Some people differ on how significant that volume limit should be, and I think Mr. Lisk and some others are on the higher percentage side.
I got you.
Thank you, Mr. Chairman, members of the committee. Tom Lisk, representing the Virginia Restaurant, Lodging, and Travel Association. And our Virginia restaurants are proud to serve Virginia craft beers. We like to promote the Virginia brewing industry, but there has been a growing concern over the last several years as we see more brewers create satellite tasting locations, which do include brewing equipment, but has heretofore not required them to actually brew beer or any minimum amount of beer at these satellite locations. And these locations really have become bars that compete with restaurants without the same food requirements. So for that reason, we really thank Senator McDougal for this bill. We think this is a great first step, but we do believe that the 20% threshold is too low. We really do believe, to the extent that these are true breweries and not pubs that are just serving beer, that at least a majority of the beer brewed that's consumed on premises should be brewed on that site. So for that reason, we would again, endorse the bill. We just think that this bill does not quite go far enough. But we do again thank Senator McDougal for his efforts.
Thank you, Mr. List. Senator DeStef.
I just want to make sure I understand the new amendments, because I was perfectly fine with this before. So if I even have one of those little home brew kits where I brew a gallon of home brew and I bring everything else in, that would comply to the law as long as I sell 20% of that gallon, or roughly one beer.
Mr. Chairman.
Senator McDougal.
I don't, what Senator DeStef said, I don't think the math adds up. 20% of the beer sold on premise must be brewed on premise. So if you set up a tasting room, got a license, and you had a 1 gallon facility, then you could not have tastings of more than 5 gallons total. So of that 5 gallons of tasting, at least one of it had to be produced there.
Got it.
So that's the bottom line. And again, I think this is where it was a negotiation in the process. Right now, there are some entities out there that have set up facilities where they're in essence brewing almost nothing, but selling a tremendous amount through their tastings. This puts a minimum regulation in place so that we eliminate that type of abuse, but that there was a negotiated amount.
Okay, any other members have a question for Senator McDougal? You have a couple other folks behind you. Do you guys really need to speak, or are you just in support of the compromise?
He's not.
Mr. Chairman, members of the committee, Miles Laurier on behalf of the Downtown Business Group. I just want to echo Mr. Lisk's statement. This is a great first step. Percentage is way too low, and we support Mr. Lisk and his organization in asking that you try to raise that a little bit. Thank you.
Gotcha. Mr. Boykin.
Yeah, thank you. Phil Boykin with the Virginia Beer Wholesalers Association. I can't stress enough that this was a long series of negotiations. What we were really concerned about is not shutting down an operation that may be currently in existence, and that's where we took out the 3 barrels and the 20% threshold. And we appreciate our colleagues with the Virginia Craft Brewers Guild for their willingness to negotiate this. And this is a consensus bill, and would hope you would stay with the consensus. Thank you, sir.
Yes, sir.
Mr. Chairman, Brett Vassy, I'm here on behalf of the Virginia Craft Brewers Guild. I do want to thank the patron for working with us. I want to thank the beer wholesalers. It did take about 6 months of negotiation to get this bill in the current format with the amended version. Just a little small backstory. We don't consider this to be a first step. This is the final and last step. So this is an important piece that we have negotiated, but we don't want to see this change again. We went 5 years ago, 3 of us started the Craft Brewers Guild with 11 members, a few $100 million in total capital investment statewide. We have 213 breweries today, $1.3 billion in economic impact. This is the fastest growing industry in the manufacturing sector today. We want to see it continue to grow, and careful, deliberative regulation is the way we do it. And this bill is that compromise, but it is the last, not the first step. Thank you.
Thank you, Mr. Vassy.
Mr. Chairman, I think we have uneasy
Senator
peace
Wagner.
in the valley. I'd move to report.
Okay. I have a motion to report and second. Clerk will call the roll.
Ayes 15, no 0.
Ayes 15, no 0. Senator McDougal, you're off the dais.
Thank you, Mr. Chairman.
Senator Wexton, you're up. Committee will bring its attention to Senate Bill 121.
Thank you, Mr. Chairman, members of the committee. This is Senate Bill 121, which should be familiar to this body. This is the fingerprint background check bill from last year. It passed out of this committee and out of the Senate and was met in the House with several enactment clauses. This bill, I do have a couple line amendments actually.
Let's take those up real quick.
I'll
I believe
let,
it was
I'll
you
let
and Senator
David-
Hanger with this bill, if I remember right. Is that correct?
That's correct.
Okay.
Mr. Chair, there are 5 line amendments. The first is on line 4. After repeal the 4th, strike and 5th enactments, insert enactment. The second is on line 4. After and the 4th, strike and 5th enactments, insert enactment. Line 6, after sunset, strike and contingency. 4th line amendment is on line 12. After that, the 4th, strike and 5th enactments, insert enactment. The final line amendments on line 12. After and the 4th, strike and 5th enactments, insert enactment, and basically it just changes the bill. Rather than repealing the 4th and 5th enactments, it now only repeals the 4th enactment.
Mr. Chairman, I move those amendments in the block.
So they've been moved and seconded, and all those in favor say aye.
Aye.
Any opposed? Okay, the bill is properly before us as amended. Senator Wexton.
So this is required by the federal government in order to be able to obtain these child care development block grant funds. We needed to have it in place by last October. It's in place. The House of Delegates put a complete sunset on it, which is what is being, we're asking that be repealed of July 1st, 2018. And then there's a partial sunset that if any of the various provisions for the various providers is determined by the new administration not to be required any longer, that part of it would be sunsetted or expire. And so we're leaving that part on there to alleviate the concerns of our friends down the hall. However, it appears that this administration seems to agree with the previous one in that this is enhancing child safety, and it does not appear that there's any movement afoot to get rid of any of these requirements.
Do any members have a question for Senator Wexton?
Mr. Chairman, I move the report.
Okay, it's been moved and seconded to report the bill. Clerk, call the roll.
Thank you, Mr. Chairman.
Ayes 15, no zero.
Ayes 15, no zeros. Let's see who's up. Give me 1 second. Okay, Senator Serville, can we take up what should be one of your easy bills real quick? I think it's Senate Bill 89. Committee will bring your attention to Senate Bill 89.
Thank you, Mr. Chairman. This bill was brought to my attention by a colleague who does a lot more of this kind of work than I do, and she pointed out that the statute that authorizes the testimony of children by closed circuit television, which currently applies in a home manner in a judicial consent for abortion cases, temporary emergency removal orders, preliminary protective orders, termination of parental rights, and child custody cases, does not provide for such testimony in juvenile court for family abuse protective orders, EPOs, or protective orders after a criminal case. And it just, I think, when I checked with DLS, they thought it was probably a legislative oversight that they just missed when they drafted it. So we're just adding these 3 extra proceedings to the ability to do child testimony by video if you don't want to have the kid in front of the person that's abusing them in a courtroom.
Any members have a question for Senator Serville about what they're trying to do?
Mr.
Senator Cosgrove.
So we're just adding 4 code sections to the bill and striking the written out 14 and 16, correct?
Yeah, we're just adding 4 additional proceedings by which child testimony can come by video, in addition to the 6 we already have.
Move the report.
Second.
Okay, there's a motion to report the bill. Any discussion? Clerk will call the roll.
Monty. Thank you. Oh, I can vote here? Okay. Neat.
Senator Serville, how long will Senate Bill 93
Ayes
take?
15, no zero.
20, 30 minutes, I think, probably.
Well, we don't have 20, 30 minutes for one
Right.
bill, so if you don't
I got
mind
it.
taking your seat, we're going to try to get
Yes, sir.
a couple of these other ones out of here. I think, Senator Favola, you pretty much have the rest of the docket, so do you have some easier bills?
All my bills are clear.
Sounds like we're doing block voting today. All right, Favola, you're up. We're going to start with, might as well start with Senate Bill 43. If 43 reports, it's got to be re-referred to finance. Oh, we struck it. I'm sorry, 44, you're correct.
Okay, Senate Bill 44, this committee has seen in the past and has actually passed it unanimously. It's the kinship assistance care bill. And what this does is it would allow the Department of Social Services to amend our Title IV-E plan so we can participate in a program which would allow relatives to receive foster care payments if they are willing to step up once their kin is in foster care. If a relative steps up and says, I'd like the child removed from foster care, the relative has to be a foster care parent for at least 6 months, has to go through some training, and agree to go to a court and have some type of permanency arrangement for the child. This is a best practice. Federal government passed it in 2008. There are a number of states participating. There's a slight administrative cost for the state. The dollars, however, the program dollars are primarily federal. And it is very worthy of passage. This really provides permanency to children in our foster care system. It also removes a burden on our system of our local system for child protective services because the children are out of the system and no longer would be requiring case management and ongoing monitoring. It's time that Virginia passed this.
Senator Black.
Senator Favola, my concern is payment allowances to the kinship guardians. Wouldn't that be sort of an open invitation to welfare fraud, where basically you could assign your child over to your aunt that lives 2 doors down, and she receives payments, and the child really has not changed status at all? Just there's a check coming in?
Mr. Chairman, Senator Black, that would not be the case. A court would actually determine the permanency. So there would be a process. The child would already be in foster care. This is not a situation where a family outside of the foster care system could loan the child to a relative. That case would not be covered under the federal rules, would not be covered under the structure of this program at all. This only kicks in when the child is actually in the foster care system. So these are children who have already been removed from their families, and they're in the foster care system. This is an opportunity for a relative to be able to step up and provide a permanent home so the child does not have to remain in foster care. Many relatives really need some kind of monetary payment to be able to do that. A fair number of the relatives in this situation are older, they're grandparents, they would like to be foster care parent, they'd like to be permanent parents for kin who are in foster care. It is expensive to raise a child now. So this is enabling those relatives to provide a home.
Chairman, follow up.
Senator Black.
If that is the case, wouldn't it also be potentially a route to bypass the court and basically a child is taken from the parent and then given to a relative who then is able to restore the child back to the original parent?
Mr. Chairman, Senator Black, according to the federal guidelines and the way this bill is written, there has to be a court-approved permanency agreement. So this has to be done through the process with all the I's dotted and the T's crossed. So there's not a way around this easily. I don't see how, because again, the state, if you will, or the state's agent, the local Child Protective Service Agency is controlling the payment of money. So they have to check all the I's and dot all the I's, cross all the T's.
Thank you.
Senator Waxman.
Question for the patron, 2 questions actually. Doesn't this, the kinship guardianship program apply only to kids for whom adoption or return home are not appropriate permanency options?
Mr. Chairman, Senator Wexton, that would be the bulk of the caseload here. Yes, these would be children, primarily older, who really would not be likely to be adopted, and they need a permanent home. So thank you for pointing that out.
Mr. Chairman, one other question. And isn't it true that the Department of Social Services is generally pretty aggressive about seeking child support from both parents in any cases where the child has gone into foster care?
Well, there certainly are incentives in place to
I see people behind me shaking their heads,
collect
so I'm
whatever
assuming.
dollars have been have been articulated to be paid by the courts.
Senator Volo, you brought this bill last year, correct?
Yes, it's a
And
very
it passed
good bill.
15-0 out of the committee last year, correct?
It did, and it is
Okay.
worthy of passage.
Okay. Senator Cosgrove.
A question for the patron.
Go ahead.
Senator, do you have a budget amendment in for this?
Yes, Senator Cosgrove, I do have a budget amendment. We have been going back and forth with the Department.
You don't have to
of Revenue.
elaborate. You got a budget amendment in? You're
And
good?
it's a,
Okay,
yes,
all right.
yeah, very small
Senator
amount.
Cosgrove?
Okay, no, that was it, thank you.
Okay.
Mr. Chairman, with that being said, it's, looking at the financial impact statement, it's about $70,000 a year plus a $14,000 local match. So if this was to get out of this committee, I'm pretty sure it would have to go to finance.
That's
As
correct.
requested by the
It
chair.
would have to be approved and re-referred to finance. So I have a motion to pass the bill and re-refer to finance. Clerk, please call the roll.
Senator Serval, vote for me.
Please.
Okay,
Ayes 14, noes 1.
okay. Let's get your next bill.
Okay, next bill is Senate Bill 61, and there's an amendment, two
Okay.
amendments.
David, can you go through the line amendments?
Mr. Chair, there are two line amendments. The first is on line 134. After sell, insert on the licensed premises for off-premises consumption. The second line amendment is on 135. After volume, strike the remainder of line 135 and all of line 136, which was the information about the ratio.
Okay.
Mr. Chairman, this is a very straightforward bill. A small business owner, Matthew Bowling, came to me, he's in the Richmond area, and asked me if I could submit a bill that would give him permission to have this home-based business where they can have alcohol-infused products, confectionery products. And his business model is the product is produced on-site and sold from the premise, and it is consumed off-site. So folks who want to buy the product can order online or make a phone call, and Mr. Bowling, I guess it's Rachel Bowling, produces the confectionery product. Somebody comes to pick it up. If it has the alcohol content above 0.5%, up to 5%, then they, would check the ID, and the individual leaves and it is consumed off-site. It's helping a small business. We did not have a confectionery license opportunity in the law, so that's what this bill does.
Is Travis here from ABC? Travis, can you just answer with a yes or no? Do we have to inspect? Is this going to cause issues with ABC and inspectors or anything?
Mr. Chairman, Travis Hill with Virginia ABC. I don't know that it'll cause problems with inspectors. We will have access to the premises that is manufacturing these, since it's manufacturing an alcohol product. I'd say a confectionery license is probably a good concept because we're having more and more of these types of businesses that want to manufacture. Virginia does not have a license for that. The only other thing I'd say is we are continuing to look at our fee amounts and what we can recover in order to enforce. And we'll be going through that this year and next on that. But otherwise, that's our feedback.
So, Senator Full, is there a fee associated with this at all yet?
Go ahead.
Travis?
It's down there.
Yes, sir, it's $100. It's in line with other fee amounts as well.
Okay.
We need to examine the adequacy of all these fees.
Okay, I got you. Thank you. Any members have a question for Senator Favola, what we're trying to do?
Mr. Chairman?
Senator McDougal.
and maybe this is for Travis, as I'm looking at the percentage in here, 5% or less alcohol by volume, is that not the same that we find in most beer-based beverages? So in essence, each of these items are the same as a beer?
Yes, sir, you do have ABV of beer that can 4 and 5%. So yeah, this would be the equivalent of eating a beer, I guess.
So, Mr. Chairman, I mean,
That's a lot of chocolate beer.
Although the
More
alcohol,
calories.
the alcohol is cooked out. Just want to say.
Go ahead, Senator McDougal.
I don't, I'm not really a beer person, but,
Okay.
Mr. Chairman, I'd like to make a motion.
Senator Sproul.
Move approval.
All right. It's been
Second.
moved and seconded to report the bill without any further discussion with the amendments.
Mr. Chairman, I just wanted,
Round one.
Did you just strike her bill?
No.
we're still on free.
Please pause for technical difficulty.
That's wrong. Should be 61. There you go. That's it.
Okay, is everyone locked in?
That's it.
Ayes 13, noes 2.
All right, ayes 13, noes 2. Your bill passes.
Thank you. Mr. Chairman, I promised the Bowlings that I would just mention they, at some point, would like ABC to convene a work group so they can come up with additional opportunities to sell their confectionery products to grocery stores or at wineries. So the request was that maybe the committee would agree to ask ABC to convene such a meeting with stakeholders.
Okay, let's do Senate Bill 120.
Okay, was there a conclusion on my request?
We can do that. We'll take it up offline.
Okay, all right, thank you. This bill is a result of some work the Commission on Youth did, and what this bill does is it directs the Alcohol Beverage Control Board to establish an advisory committee that would include representatives from the SHEV, and the purpose would be to look at best practices that universities are doing regarding the use of illegal substances and the impact, how to prevent such use, and what to do, how to intervene. We did have a commissioner, and we still have a commissioner on the Commission on Youth whose daughter died. She was a student at UVA and had one time participated in recreational use of a drug, and nobody knew how to intervene, and it was a very sad situation. So the commission has heard a lot of testimony. We're very committed to actually working with the universities and trying to ensure that enough education is done and knowledge is out there on peer mentoring and peer counseling would be part of it. So there's no fiscal impact. We worked with ABC, and on behalf of the Commission on Youth, I ask that we pass this.
I have a note that it says it does have to go to finance. There is an impact to it. So if we do report the bill, I think we have to re-refer it to finance.
That would be a different thing.
Second.
Okay, so the motion is to report and re-refer to finance. All right, clerk, call the roll.
Ayes 12, nays 3.
Motion carries, ayes 12, nays 3. Next bill.
Mr. Chairman, I'm going to continue with bills that have come out from the Commission on Youth. I have to change the consecutive order a little bit. I'd like to go to Senate Bill 182.
Okay, committee will bring its attention to 182.
And it has to do with extending a hearing. There was a situation, actually it was in Arlington County, a school employee had been accused of a sexual assault, and the local Child Protective Services had a finding some, I guess in non-technical terms, there was evidence to suggest that something had happened. And then there's an appellate process. So the individual can appeal. The appellate process goes through the Department of Social Services. And what we had found out as we were learning about the system is, in effect, the accused individual can continue to ask for delays in the hearing. And that's problematic because oftentimes the individual has left the employment of that school system, is looking for another job. This appellate case is still pending. There's no resolution. Employers would not have access to, adequate information because the appellate situation is still going on. So what this does is it says no more than 2 extensions may be granted on the appellate calendar, and no event shall any extension cause the hearing to be delayed by more than 90 days. And we thought this was a necessary step to take.
Okay, any patrons have a question? I see Senator Serval, go ahead.
Speaking to the bill, Mr. Chairman. And I've already spoken with the patron about this and also with the Youth Commission people. I actually, last night I sent an email to about 5 different people that do this kind of work, and they wrote back to me that they've had attorneys who've had situations where they've felt like they needed to continue cases either because they had a client who didn't have money they had to get money together to buy a transcript to do the appeal, or they need more time to prepare for it. And these proceedings are quasi-criminal. They're very serious proceedings. You're basically talking about branding somebody as a child abuser, and given the severity of what the system is doing to somebody, it's important that people get maximum due process. And if we're trusting the hearing examiner to basically make this decision, I'm not clear why we would limit the hearing examiner's discretion to provide the parties appropriate time in order to prepare the case or hear it or argue it. So while I'm sure it's well-intentioned, I just would prefer we leave the system with sufficient discretion to figure out when they want to hear the case instead of putting a cap on them. So I don't like the bill based on the input that I got from people that do this for a living.
Thank you. Senator Sproul.
Mr. Chairman, based on what he was saying, once you go to court and they're staying all day long, and she was saying that they have 2. So you mean tell me after you go to court, you stay all day long, and then you want to appeal it, delay it, my term, delay it 1 time, then you want to delay it a 2nd time. So lawyers are smart, supposedly. So why is it after the 3 times? I'm trying to figure out after 3 times, what reason would you want more time to delay it for, unless you're just trying to get somebody to drop the case? In most cases, I'm trying to understand that I believe that after the 2nd time, the 3rd time in court, that why you need more time to do this to Mr. Sitwell.
Senator, hold on 1 second, Senator Sproul.
Yes, sir.
We'll get that answer to you.
Yes.
Did you want to comment?
I was going to,
Senator McDougal.
Mr. Chairman, as those of us who are in court know, sometimes things happen to key witnesses. They get hit by a car, they get the flu, or maybe there's somebody involved in the system and they were subpoenaed to be in another entity like a circuit court and they couldn't be there. So there can be a myriad of reasons why situation would need to be continued again. Particularly, these hearings usually come about very rapidly. So the first hearing could be a very short time frame. You could set the other one out for a not too long time frame and then not be able to get the witnesses. You might not be able to confirm the witnesses' availability when you're sitting the case. What I think Senator Serval expressed, and I candidly have a concern, we're giving these hearing officers the authority to make the decision about whether the individual is in essence guilty of neglecting a child. Shouldn't that hearing officer also be able to determine whether that case should go forward on that day? I mean, they can deny the request for a hearing. Now we're not giving them any discretion at all. And I think that's a practice legislature has done in a lot of areas. Maybe we need to be reluctant to do that going forward.
Senator Wexton.
Question for the patron, Mr. Chairman. I'm kind of curious how you came up with this language on line 53, absent upon a showing of compelling reasons to justify the extension. Every other part of the code that I'm recall seeing, talks about good cause shown. So how did you come up with compelling reasons as the threshold for, and where are compelling reasons defined in another location in the code?
Well, maybe I didn't provide adequate context. The situation that we were trying to correct and we don't believe is necessarily unique is the individual left employment while the appeals case was going on and was hired by another school system. And the school system didn't have access to information because the appeal was still going on. So we're talking about individuals where there was harm to a child, and we wanted to ensure that we could complete the case in a reasonable amount of time so other employers who would be likely to interview this perpetrator and possibly offer the perpetrator a job would have access to the information. We were trying to balance a due process argument with bringing closure to a case when we understood that, the perpetrator, if you will, would be out looking for another job and will get hired because the appellant process was still underway. It was a very difficult conversation. We had witnesses on all sides. This was sort of a joint a consensus language from the Virginia Education Association, which was obviously very concerned about teachers. And then we had the Department of Social Services and actually Channel 4 News up in Northern Virginia had done an episode on this. They were at our hearings and listened to the debate. In terms of your specific question about compelling, I think the drafters who were, David May was with us at the Commission on Youth as we went through all the hearings. They came up with the word compelling.
Okay.
Would you like to respond?
Let me,
Mr. Chair, if it satisfies the committee and Senator Wexton, we could replace compelling reasons for good cause shown. Good cause shown would include compelling and necessitous reasons.
is that a motion, Senator Wexton? Okay, so we're not making any motions.
Mr. Chairman, I have a question.
Senator Mason?
The attorneys give us good reason not to put a finite timeline on a process that could have unusual circumstances, even in light of a horrible situation. Is there any way that we can come up with a manner to show that a person is subject to a hearing or in the process of having a hearing being heard, so the next employer would note, I know it's probably a personnel matter, you can't say what you're being, is there?
There were a lot of due process questions around that. This is where the committee came down. I will ask if I have any of my experts here. I will.
Yeah, Mr. Chairman, Senator Mason, currently the discussion was over, you can't enter the central registry until all administrative appeals are exhausted. And so that's where we were hampered on this issue. But that's sort of the direction I hear you're looking at.
Wait, one more question, Mr.
Okay,
Chairman. So
Senator Mason.
even in the state of Virginia, this was another state. So if this person goes to transfer from one school system to another in the state, they still have no way of knowing that that person is subject to a hearing at the police.
Included.
Thank you.
Unless they hear from the local school board.
Mr. Chairman,
Senator McDougal?
but there's nothing that prohibits the employer from asking the potential employee, are you subject to any hearing? And if they lie on that form, then that is cause for them not to be employed.
All right, Mr. Chairman.
Okay, Senator Cosgrove.
Mr. Chairman, I'm listening to the attorneys around the table. There's great unrest on this bill, so I would move to PBI.
Okay, I have a motion to PBI. Is there a second? There's a second. So the motion is to gently PBI the bill. All those in favor of PBI? Okay, so 13 yeas, 2 nays. That one's gone bye-bye. Senator Full, I need you to come back and have a seat. We're going to take up Senator Chafin's bill because I know you've got a few more left.
I have a few more left.
Yeah. So Senator Chafin, I think you have witnesses here as well. For your bill, it is Senate Bill 382.
Thank you, Mr. Chairman. What we have here is this good bill that's called the come to rest bill. And apparently, there's a common term in the wine and beer industry known as come to rest. Come to rest is used to describe a statutory or regulatory scheme where there's an interpretation that mandates beer and wine be delivered to a distributor. My bill codifies the ABC Department's longstanding practice as codified in Section 4.1223. Our bill also adds an additional clarity to that interpretation by adding a 4-hour period at rest provision. So what essentially happens is under this scheme, the inventory has to be offloaded. It sits still for 4 hours and remains on the licensed premises before it goes on. And that's the bill.
Thank you, Senator Chafin. Senator, stand at ease just for a second. Okay, Senator Chafin, I'm going to tell you we've got about 10 minutes in which to kind of adjudicate your bill. And I know you've got witnesses. So does anybody from the committee have a question about this bill for Senator Chafin? Okay, Senator Chafin, do you have some people you want to bring up to speak to the bill quickly so we can get those for and against what you're trying to do?
I believe so.
Okay.
This will be quick. The wine wholesalers support the bill.
Phil Boykin, the Virginia Beer Wholesalers, we wholeheartedly support this legislation. Thank you.
You're taking opposition out.
Yeah. Yes, sir.
David King, King Family Vineyards, Chairman of your Virginia Wine Board. Here on behalf of the Virginia Winery Distribution Company, created by the General Assembly 11 years ago to allow Virginia wineries to wholesale wine with a very unique device directly to retailers. We reluctantly oppose the bill for the following reasons. We cannot, by the very nature of the VWDC, actually offload from a delivery vehicle. We're working on that with Travis Hill about trying to redefine what a delivery vehicle may be so that we can technically, the wineries that use this device can technically comply. The second is more intrinsic, again, for the unique reasons that the VWDC was created. The ability to immediately respond to a retailer's order is intrinsic to the reason that VWDC was created. Typical fact situation, 10 o'clock in the morning, retailer calls. By 3 o'clock that afternoon, the winery, acting through the VWDC as a wholesaler, can deliver that wine. This 4-hour requirement really does strike at the heart of the usability of the VWDC, and therefore we reluctantly oppose the bill.
Thank you, sir. Yes, ma'am.
Terry Byrne again, Mr. Chairman. The California wine industry is opposed to this legislation. There are come to rest laws in 20 or so states in the country, and they are being, the pace of business is increasing, not decreasing. And these kinds of bills are slowing down just-in-time deliveries for wineries. And there's the impetus for this bill hasn't been made clear to me. There's been a suggestion that there are wholesalers that are bad actors that aren't complying with current law, but we've not seen any evidence that that's a problem, and we haven't heard from ABC that they're having a challenge enforcing the current law. And if there is a problem, let's give them the tools they need to enforce the current law, either new laws or more people, and we'll see if that doesn't solve the problem. Thank you.
Thank you. Mr. Adams.
Mr. Chairman, members of the committee, Trey Adams on behalf of the Country Vintner and Wine Bow. We service our Virginia customers out of a 170,000 square foot warehouse in Hanover County. It's across the street from Bass Pro Shops, to give you some perspective. We move 1.3 million cases of wine through there a year. We pay almost $2 million a year in excise taxes. The burden on us in record keeping and monitoring to ensure that for some reason that case of wine needs to sit for 4 hours before it goes out to a customer in a restaurant who wants it that night is really quite a burden. And as Ms. Burns suggested, I think this is a solution in search of a problem. There's statutory authority at ABC. If the character of a wine wholesaler is such that they're not complying with the law, they have a license that can be investigated and revoked. The current statute requires that it be consigned to them. The only thing it doesn't have is a time limit, and an arbitrary 4 days is really too much, given the fact that time is money and clients and customers require 4 hours, sorry, require just-in-time delivery. There are restaurants who look around on a Tuesday afternoon and realize they need wine that night. We've got to move stuff around, and so for that reason, we really would appreciate the rejection of the measure.
Thank you, Mr. Adams. Senator Chafin, you want to summarize?
Yes, Mr. Chairman. This bill is needed in Virginia and was found to be needed in quite a few other states. The 4 hours is not an arbitrary period. It's lower than a lot of those other states. Arizona, for example, has 24 hours. So, what this prevents is situations where the spirits are not being taxed. Okay, that's what it prevents, where there's a bump and run that goes on and they simply drive on the parking lot and right off the parking lot and boom, and they're out of there. And I'm not suggesting that any of the players that are here testifying, that we have good actors here testifying today before this committee, but nonetheless, the ABC is just simply not able to enforce some of the things that are going on, and this simply codifies and gives a period of time to what the spirit of the law is right now and what the way that ABC interprets it.
Thank you, Senator Chafin. Senator Cosgrove.
Thank you, Mr. Chairman. Senator Chafin, I've actually talked to some other wine wholesalers. I know Winebo is here in opposition, but those other wine wholesalers are in full support of this bill. We have a franchise way of doing business with alcohol here in the Commonwealth, and I think this solidifies what we already expect of our franchise laws. And with that, Mr. Chairman, I move to report the bill.
Second. Okay. I have a motion to approve and second.
Chairman.
Senator Hanger.
I just wanted to make a statement. I know you have your motion now, but this is a bit of a difficult position I find myself in right now. And I intend to support this, but I need to qualify that, hoping that we may be able to tweak it in the process. First gentleman who spoke in opposition to the bill, Mr. King, David King, a number of years ago, I sat with him over at his place of business in Crozet. We drafted on a legal pad what became the Virginia Wine Distribution Center here that has been very successful in promoting Virginia wines and enabling the distribution. So we've got a lot of good players on both sides of this issue here. I understand the bill, and I essentially am committed, Senator Chafin, to support it, but I'm hoping if we can identify some issues there that can be resolved that are causing concern with the Virginia Wine Distribution Center, that we address those in the process. Thank you, Mr. Chairman.
Senator Hanger, I appreciate your comments because I would echo those same comments. If this bill seems to find a lot of day today, that we could get together and try to work through some of that, even with Travis and ABC, and really get to the root of it. I understand this is a stopgap fix, but when you've got people that want to get to the table, Senator Chafin, I think that's a good thing. So with that, we have a motion before us to move the bill forward. Clerk will call the roll.
Ayes 15, no 0.
Okay, ayes 15, no zeros. Ladies and gentlemen, it's the witching time. I'm sorry we could not complete the docket, but at this point, the committee will rise.